Next case will be a grant, in re Williams Minors. Mr. Sankrin, I don't think it was your argument that they were here to hear. They were here to hear today.
We cleared the courtroom out, Your Honor.
Please bear with us for just a moment. Okay, this argument will be 20 minutes per side, and you do have a 5-minute free fire zone. Please proceed.
May it please the Court, Vivek Sankran on behalf of the appellant Jack Williams in this case. I'd like to reserve 2 minutes of my time for rebuttal, and I would invite questions at any point and waive my free fire period. The Michigan Indian Family Preservation Act expressly gives parents who release their rights pursuant to the adoption code the right to withdraw that release prior to the finalization of their child's adoption. MCL 712B.13, subsection 3, makes that clear. In this case, the appellant, Mr. Williams, executed a release pursuant to the adoption code to his children, then learned that the adoption had been disrupted, had fallen apart, had then filed a motion with the trial court invoking the protections of the Michigan Indian Family Preservation Act to withdraw that release, and the trial court denied that request in violation of MIFPA. At various points in the proceedings, both the trial court and the Court of Appeals and now the Department have offered varying rationales to ignore the plain language of the Michigan Indian Family Preservation Act. So first, on the trial court level, the trial court denied his request, saying that this provision of MIFPA only applies to what we call direct placement adoptions. Those are adoptions under Section 43 and 44 of the Adoption Code, where a parent picks a particular person to adopt a child. We're not saying that that's this type of adoption in this case, but the plain language of Section 3, 712B.13, subsection 3, states the withdrawal applies to either a release of parental rights under Section 28 or 29 of the Adoption Code, or a direct placement adoption under Section 43 or 44. And the Court of Appeals correctly recognized that. So in this case, the Court of Appeals disavowed the rationale of the trial court, and the trial court got that wrong, that MIFPA does apply to releases of parental rights under the Adoption Code. But then the Court of Appeals said, regardless, Mr. Williams was required to do something else to consent to the termination of his parental rights, in addition to releasing his rights under the Adoption Code, under Section 23 and 24. But the court then doesn't specify what exactly a parent in Mr. Williams' situation is supposed to do in addition to releasing his rights under the Adoption Code to consent to that termination, to invoke this protection. That's through the mystery of the Court of Appeals' opinion, is that the law contains nothing else that a parent has to do to consent to the termination of their parental rights other than execute a release of their rights under Sections 28 and 29 of the Adoption Code.
Mr. Sankar, I want to ask you a couple questions about the particular form, the release form and the accompanying statement. I don't understand forms, court forms, but I know that there are different ones that are used by different courts, it seems, in termination cases. And the form in this case is called a release. It's a SEO approved form. It looks like from your appendix. But I see that there are other forms that are sometimes used in termination cases that are different from this one. Does that matter? Does it matter which form was used?
So I think it does matter. And I think the forms that were used in this case do not reflect the statutory protections in the Michigan Indian Family Preservation Act. These are sort of standard forms that are used in any child welfare case when a parent is releasing their rights under the Adoption Code. what the Michigan Indian Family Preservation Act basically says that releases by Indian parents are just a different class of, just as if child welfare cases in general involving Indian families are just, they have different sets of protections. And so that was the key error here. So when you look at the language in subsection 3, when they talk about, a consent should be executed in conjunction with a release,
right.
Our reading of that is that it's the obligations, what that's talking about is the extra obligations on the part of the trial court to properly advise parents of the rights that they have under the Michigan Indian Family Preservation Act. If you go back to subsection 1, 712B.13, subsection 1, everything in there is about what the trial court has to do before. Yeah. It has to be before a judge, which in this case, this release was not before a judge, it was before a referee. And then there are very, very specific requirements about what type of advice of rights must be given, which are different than the ordinary advice of rights given to a parent in a typical adoption case.
And is there anything, therefore, to the state's argument that given that we agree, it sounds like everybody agrees that those things were not done, the Section 13 requirements were not met, that therefore it wasn't a valid Section 13 release for your client? I mean, no. Should your client pay the cost of the invalid Section 13 release?
No, not at all. I mean, the statute's still entitled my client of these protections. Under the law right now, under the Michigan Family Preservation Act, any release by an Indian parent under the adoption code falls under this section. The extra obligations were all on the part of the trial court. There's nothing at all that Mr. Williams should have done that he did not do to invoke his protection under this right. I mean, he filled out the paperwork given to him. When the adoption dissolved, he filed a motion with the trial court to set that aside within the time frame of the Indian Family Preservation Act. And so that's sort of the mystery of the Court of Appeals opinion, is figuring out what exactly the court wanted him to do that the statute required him to do that he, in this situation, had failed to do.
Mr. Sankrin, I understand your argument. I think I understand it, reasonably well, that the additional obligations that have to be satisfied with regard to an Indian parent are all for the additional protections of the Indian parent. But with regard to the Court of Appeals, I guess I can understand, and perhaps you can too, that the language "in conjunction with" seems to imply that there are separate documents that have to be complied with, and that there weren't those separate documents in this case. And perhaps, arguably at least, the Court of Appeals ran afoul of this provision by looking at that phrase and confusing what it meant.
I would agree, Your Honor. I mean, I do think that the wording of that statutory provision is confusing. I don't think it's ambiguous in terms of what it requires Mr. Williams to do, but the consent that it talks about in subsection 3, it says a consent in conjunction with the release, but then it says a consent under subsection 1 is how it's phrased. If you go back to subsection 1, it's all about what the trial court has to do. It's all about the notice. There's nothing in subsection 1, which is a very sort of brief, short, it's all about notice to the tribe, the name of the Indian child, advising the parent that they can withdraw the release at any time. And so to put that burden on Mr. Williams as if he could have done something else in this case other than what he had done is, I think, where the error of the Court of Appeals argument is. The third argument that's been put forth, so at the trial court they said it didn't apply to releases. That was wrong. The Court of Appeals said that there was some other document that Mr. Williams needed to fill out. We believe that that reasoning is incorrect. The third rationale now put forth by the Department is that subsection 5 of this, which says that a release conducted pursuant to a child protective case is subject to 712B.15.
So that's where I was going next, so we're all on the same page. So that is a confusing, there's some confusing text in there for me, right? And you tell me where I'm going wrong, because my understanding is that if you're in Section 15 proceedings, the state is seeking to terminate parental rights of an Indian parent. There are certain extra protections that the Indian parent is entitled to if the state is seeking to terminate. If the Indian parent says, I willingly consent to release my parental rights, it seems to me you're moving from 15 to 13. What does 15 have left to offer somebody who's consenting?
So I think 15, so this is actually, there is a debate within how to interpret MIFPA as to whether the 15 requirements apply regardless, even when someone is consenting.
Oh, really?
So
some people, that's not present in this case, I guess.
It's not present in this case, but there is that some courts, even when a parent releases and the protections of 13 apply, are still making a finding of active efforts, still having an expert come in to testify that, to make the findings within Section 15.
So we're going to have to decide that eventually. That's just not here yet, is what you're telling me.
Perhaps,
Yeah.
but that's not at all our argument at all. And I actually do not believe that it makes any sense when a parent is voluntarily saying, I want to give up my rights, that the court could somehow require extra findings and say you can't do that if those other findings aren't present in this case. But courts have been making those additional findings. What courts have been doing is applying both subsection 13 and subsection 15. And I think the confusion, Your Honor, is that when a parent voluntarily releases their rights in a child protective case, you really have two sets of proceedings going on top of each other, because a release is done pursuant to the adoption code. Mm-hmm. It's almost like a brand new case is opened up, because there's no way a parent can release their rights in the child protective case. There's nothing in our juvenile code that creates a special, it's all within the adoption code. And so I think because of this unique situation where you have a child protective case, but then you have sort of a release that's taken pursuant to the adoption code, that's what invokes both 13 and 15 together. But I agree with Your Honor that there's very little of 15 that I think comes into play.
Once you're releasing.
Except if I may just add, Your Honor, the one thing that would come into play is that provision within 13 that says, if you withdraw your release, the child shall be automatically returned home. That clearly, when there's a child protective case, and that perhaps it gives meaning to 15 to say, no, there's a child protective case going on, that those orders spring into effect. That we are not asking, in this case, in terms of our statutory construction, that when a parent in a child protective case withdraws their release, that somehow that entitles the child to go automatically home.
Yeah, so that was another question. What exactly happens if in a withdrawal, when you started out in a 15 case? I mean, you could imagine a case where the state was had almost completed all of its obligations under Section 15 and would have, but for a voluntary release, had an order that was compliant with 15. And, then all of a sudden the state has to start over again? No,
not at all. It would just revert back to the stage at which the child protective case was at when the state made a choice. I mean, in this case, the state made a choice. They filed a termination petition. It was set for a contested termination trial, and it lessened their burden to accept the release by Mr. Williams, but built into that is some risk. Right? And at that time, the risk wasn't apparent because everyone was on the same page that this child was going to be adopted by this adoptive parent. The state could have proceeded to seek an involuntary. So in this case,
so if you're right, it still can.
Absolutely. Okay. Yeah, absolutely. On remand, there's nothing that would prevent the department, if they can meet their burden, of refiling that very same petition to terminate parental rights in an involuntary. But they'd have to meet then all of the requirements. There's no dispute. They'd have to meet all the requirements of 712B.15.
So can you indulge me in a legally irrelevant question that just keeps clouding my judgment here?
Absolutely, Your Honor.
This whole withdrawal was brought about because the adoption by the foster family came to a halt in Oakland County.
Correct.
And that appeal pursued at the same time this appeal. And that appeal now is back to the Oakland County Circuit Court to put the adoption back on track. I mean, it's not guaranteed, but it's back on track. So why are we here today? Why isn't there some sort of resolution that as long as this adoption goes forward, I'm not going to withdraw?
Because at this point, it's a different family, Your Honor. It's not the same family that was selected to be the initial adoptive placement. So the children were moved.
I see. From
one home to another after it disrupted. And so that's why this is still alive.
So what was the Oakland County appeal moot? If it's a different family, I mean, what was the point of that appeal?
I believe that at that point, the previous adoptive parents were looking for the Court of Appeals to reverse the judgment by the agency and the court and send the kids back to the old adoptive placement.
I see.
And so that's why there's still a live dispute in this case.
Okay.
So a consent is always done with regard to a particular family. There's not a more generalized consent to the fact of some adoption. It's a specific adoption. I'm okay with this family, but perhaps not some other family.
No, Your Honor, there actually, so I'm glad you asked that, Your Honor. There's two different types of consents under the adoption code. One is a release of parental rights to a child welfare agency for the purpose of adoption. And that's the most common in a child protective case, that the parent isn't picking a particular, I mean, they all know who the family is because the child's been in a foster home. There's usually no guarantee that the child will remain there, but it seems like the case is heading that way. That's sort of situation one, and that's under Section 28 and 29 of the adoption code. Then there's what's called a direct placement adoption, where the parent says, I will consent to an adoption by these specific people. What's telling about MIFPA, the Michigan Indian Family Preservation Act, is that it specifically covers both. That it covers both the general release to a child welfare agency, and subsection 3 makes that clear, and covers situations where someone specifically selects a particular placement for a child. The other point I wanted to make, just to clarify our position, is that we are not bringing a case under the Indian Child Welfare Act. I wanted to bring that up just because some of the amici briefs sort of referenced the Indian Child Welfare Act. Our argument is purely a statutory argument under state law, under the Michigan Indian Family Preservation Act. I think it's important because if you look at the way that MIFPA was drafted, it is more protective of the rights of Indian parents than the federal Indian Child Welfare Act. And so, for example, we could not bring this case under the Indian Child Welfare Act because it specifically says that a parent can only withdraw consent to termination before the final decree of termination. And so in this case, once the release was adopted, the trial court entered an order terminating his rights. Where MIFPA is more protective is it doesn't say that. It says the parent can withdraw the release of their rights at any time prior to the finalization of the adoption. And we think that that language is significant, obviously, for obvious reasons.
Mr. Sankaran, could the state have said, I mean, I guess they could have. They could have just proceeded to trial. When your client said, I'm going to consent to release, could the state have said, no, we don't agree, and we're going to set the trial, and we're going to proceed with our termination proceeding and fully adjudicate this case under Section 15 because we don't want to risk you changing your mind?
Absolutely. And there have been cases that I've been involved in on the trial level where the state has rejected a release, in part because they want some of the collateral consequences of an involuntary termination, right? That when a parent has another child, there's certain things that come into play and where you don't want to let a parent release their rights because they want the findings that you can then use in further proceedings. They certainly could have done that, but again, proceeding to trial in this case, they would have had the MIFPA and the Indian Child Welfare Act standards are incredibly high to meet in a termination case. It's a beyond a reasonable doubt standard. And so I get why the state at the time it did decided to make the choice that it did. If there are no further questions, we would ask the court to reverse the trial court and remand the case back for further proceedings. Thank you.
Thank you, Mr. Sankaran. Mr. Ainge?
Good morning, Justices. John Angie, excuse me, on behalf of Plaintiff Appellee, Michigan Department of Health and Human Services. I want to go to some of the questions that were asked, to do this a little backwards. As it relates to the question, Justice McCormick, regarding could the state have gone forward with a hearing that day, asking for termination of parental rights, absolutely the state could have done that. There's some reasons why, when you're in the position of petitioner, that you don't do that. Of course, you're leaving the decision up to the court, and even though there's great respect for the court, there are some unknown factors that could take place. When you get a guarantee, when someone steps forward and says, I want to release my parental rights, it's a little unusual, having tried many and many of these cases over the last 30 years, to reject that for some hypothetical situation that could occur. Of course, we now find ourselves in that situation. However, also, Having represented parents under an exclusive contract for a couple of years in the past, I can tell you that there are some reasons from the parental point of view where you do that as well. I have learned a lot about my clients during termination hearings or adjudication hearings that I didn't want to learn and I didn't want the court to learn, both involving criminal behaviors and otherwise. So there are some motivations and benefits that are garnered from a parent who decides to do this. Also, there are situations where a parent has decided to partner with someone who may have children. You testify in court, you could put those children at risk for removal as well. I'm only saying that to indicate that there are some definite advantages from the parent's point of view to doing what was done here as opposed to simply allowing for adoption. As it relates, Brother Counsel made a statement about consent to adopt and placement with the adoptive family and that the children were removed from that choice. But understand, the choice was not that of the respondent fathers. The choice of placement was the choice of the Department of Health and Human Services. This is not a situation, I want to make it clear, because Justice Markman and Zara both asked a question about placement with the adoptive family. This wasn't a placement by the respondent father. This wasn't, I'm making a choice and now that choice has been somehow changed for me by the state. That was a choice that was made by the placing agency, which was the Department of Health and Human Services. I want to make that clear. As it relates to subsection 5 of the statute involved here, which refers to subsection 15, I think it is relevant. And I think it's interesting, the amicus briefs in this situation are very telling and they're very interesting. You have the Chippewa tribe, who's been involved in this case since the beginning, advocating for this court to affirm the Court of Appeals and allow termination of parental rights to basically have effect. You have the national tribe has indicated that that should be set aside. I find it very interesting that when you bump up, you have two statutes kind of bumping up against each other. You have MIFPA and ICWA bumping up against the Child Protection Code in the state of Michigan. It's very clear that Section 15 is what applies here based on paragraph 5 of 712B.13. Now, I do know that there is some ambiguity here. I acknowledge that. But it's very clear that subsection 15 does not provide for any type of withdrawal or release of parental rights. I think that's telling because you have a situation here not involving a consent to adopt necessarily. What you have is basically an involuntary termination that has now been turned into a consent for adoption. So I think it's very telling that you at least rely on subsection 15 to guide when there is a child protective proceeding in effect. Are there any questions?
We were giving you your 5 minutes. We were trying to, yeah.
So on that last point, though, Section 15 does use the words "and" if a parent does not provide consent as described under Section 13 of this chapter. So if the consent was under Chapter 13, wouldn't that diminish your argument?
No, I don't believe so. I don't believe there is a consent per se. I don't believe the word consent applies here. I think there is a voluntary termination of parental rights, a release of parental rights. But to use the phrase consent indicates that I'm consenting to this group to be adopting this child. That's not what happened here.
Do you have anything further?
No.
Justice Bernstein?
You know, I guess I'll ask a question. Counsel,
We please.
Come back.
yeah, I'm sorry. I guess what I'm trying to really understand from this case, and if you can help me through this, and I'm going to ask your brother counsel the same question, is I've got a number of different competing interests here. I've got the parent, I've got the tribe, I've got the state. I have all these competing interests that are kind of playing a role in this case. If you could help me to understand why you feel that your position is truly in the best interest of the child.
It's interesting. I'm glad, Justice, that you brought up the best interest of the child because the competing parties that you listed didn't include that, but I'm glad you included that at the end because we've had a situation here where these children have been temporary court wards since 2013. Parents were given well over 2 years to rectify the problems that brought the children into care in the first place. In 2015, when the agency moved for termination of parental rights, And I would note that if you review the transcript at that hearing, all the full rights afforded to respondent father under ICWA, under MIFPA, were provided to the father. Reasonable doubt standards. All the standards and all of the things that he would have a right to were explained to him fully when he released his parental rights. So to take children who've been temporary court wards since 2013, made permanent court wards in 2015, placed in pre-adoptive family for all of this time, and basically the youngest child has been out of the parental home since birth. Given that stability that they've had since those dates, I don't know how it could be argued that it would be contrary to the best interest to set aside this release of parental rights.
Can I go back to your 1513? I think you were saying that this, tell me if I understood you correctly, that this wasn't really a consent or a release, a voluntary release. It was almost a Section 15 termination that the Indian parent kind of, I guess, agreed to give up the Section 15 protections to? Is it sort of like it's not really a Section 13 consent, it's a Section 15, I don't hold you to your 15 burdens?
No.
What is it?
To use the word consent almost sounds as if, and what it really is I'm consenting to these folks adopting these children.
But the statute says he can release either way. It doesn't, and nobody disputes that it was a release to the agency. Right?
Correct.
I mean, so what is that? That's sort of irrelevant to my question. My question is, if it's not a voluntary release that gets him the benefits of Section 13, what is it? What do you think happened here? What would you call it?
I would call it a release, but what I would call is a release because of paragraph 5 and 13, which refers you to subparagraph 15. And I guess that's where the ambiguity lies, because if you're going to go to Section 15, then why is there not something included in that section that allows for the withdrawal of the release up to the time of adoption?
So you think then it's a Section 15 release, then would you concede that he didn't get all of the Section 15 protections? We have to go back and we need a trial and beyond a reasonable doubt and all the...
No, because I believe if you look at the transcript that he was given those rights, he was given the options of those rights. He was given the option to execute and exercise those rights had he decided to have his evidentiary hearing.
So maybe Section 15 should have had an extra release option in it that would make it clear that it's like a Section 15 release and not a 13 release that gets you.
And
so
I think that would be
that's where the sloppy drafting kind of.
Yes, and I do agree that would be beneficial, and therein lies the ambiguity.
Right.
Well, thank you again, counsel. I appreciate that. Time is out.
I did, but I have a
He had
question.
2 more minutes, actually. He's got 2 minutes.
No, he didn't preserve it, though.
Yeah, he did. He asked you, and you said
Yeah,
yes.
he did. Okay. I take your word for it.
So, counsel, if I might, I'd like to pose the same question to you in terms of your arguments and what you're asking this court to do. Help us to understand why this is in the best interest of the children.
So I'd like to take the question just back a step, which is that this statutory scheme and the Michigan Indian Family Preservation Act in this section actually doesn't ask the court to make a finding about best interest when determining whether to allow a parent to withdraw their release.
I understand that, but I still want to understand, in terms of the children that are affected here, I'd like to have an understanding from you as to why this is important, why this is significant, but what impact this will have on the actual children.
Sure. So certainly my client, Mr. Williams, believes that he would like to regain custody of his children. He thinks that it's in the best interest of his children to be with him. I mean, child welfare cases are often hotly contested debates by different people about what they think is best for a child. And in this case, clearly, the department has a position on what they believe is best for a child, as does my client, as does the children's lawyer, as does the tribe. And in this case, the case will be remanded back down below for the court to make a determination about what is best. But the Michigan Indian Family Preservation Act made a policy choice about what's best for Indian children based on the historic destruction of Indian families involuntarily, throughout society by reading and writing these protections into the law to allow parents to withdraw their voluntary release. And so I think that there's a fact-specific argument that my client will make at the trial court about why it's best for his children. But the reason this law is in existence is the systemic issue about the historical injustice done to this particular group of people. As it relates quickly to this consent question, I want to make it clear to the court that in Section 13, I would ask the court to pay attention as to how the drafters use the word consent. They're not just using it to refer to consents to specific placements, but do talk more broadly about releases as well in the context of what it means to consent. Thank you, Your Honor.
Thank you very much. Thank you both.